Now, guess what? I have just the best set of experts in this country to help us deal with these matters. Here in the studio this morning, Nana Kwabena Acheampong is Senior Programs Officer, Team Leader, Security Sector Governance, Local and Urban Governance at the Center for Democratic Development, CDD, Ghana. Nana, good morning and welcome to Newsfile.
Thank you.
Great. Also in the studio is Colonel Festus Sabuaji, retired, author and consultant, peace and conflict research, and he conducts training in these areas of his expertise. Colonel, thank you very much for joining us.
Good morning and thank you.
Good morning. Also here in the studio is Dr. Kwesi Enin, Director, Faculty of Academic Affairs and Research, Kofi Annan International Peacekeeping Training Center. Thank you very much for joining us, sir.
Thank you.
Also, we have a man who spent 6 years, okay, in your time you spent 4 years, 4 years reading the law and behaving as if there was no other place in the world but your library and your study. Martin Pebu is a lawyer and a rights advocate. Thank you very much for joining us.
Thank you, sir.
Right. Okay, so I shelve my take and we get straight to deal with the matters that engage our attention this morning. So, simple question. Will the commission set up by the President, Commission of Inquiry, set up by the President, punish perpetrators of the bloodshed in Bawaleshi, and will it resolve all the matters related thereto? That is the big question. We'll have also to deal with the questions of the criminal acts and impunity in the name of political vigilante and how these political hooligans are unleashed on this country and poor, innocent citizens, particularly during by-elections and elections. How shall we end that phenomenon for good? Right. So, I'd like to begin with Martin. So you are the one who is, like I said, spent 4 years reading the law, and the Commission of Inquiry, certainly there's provision for an allowance for it under the Constitution. So what do you say? Will it punish the perpetrators? Will it resolve the issues?
Okay. I think by and large, it would help us in the right direction, you see, because what it is that we should be informed by history as well in matters like this. I've seen material around in the NDC and all that against the setting up of the commission and all that. But you see, if you look at our history, people who engage in electoral violence have been punished before. But the question is, did the punishment curb the violence altogether? Let's start from 1960. You know the case of R.V. Jemfi. In the Winchi by-elections in 1959, UP supporters threw stones at CPP supporters, and Jemfi's stone killed one person. Jemfi was tried and convicted, first of murder, and then on appeal, it was reduced to manslaughter. He was jailed. So if the logic of the argument is that it must be in Sawam all the way, then electoral violence would have been curbed in 1960. Apart from Jemfi's case, there are other reported cases. So the point I'm making is that our history shows that deterrence alone is not sufficient. So based upon that, I'm inclined to go with the setting up of the commission.
What's your confidence in the individuals forming this commission? And they are Mr. Justice Emil Short, who is the chairperson, Professor Henrietta Mensah Bonsu, who is a member, Mr. Patrick K. Acheampong, who is a member, and Dr. Ernest Kofi Abochi, former Dean of the Faculty of Law, GIMPA, and a lawyer who is the secretary to the commission.
I'm absolutely confident in them. I think that's the right squad for the job. It's all good. I mean, we know there's Emil Short, very distinguished. We know the work he did at Shraj. Remember, we're routing for him, for her to become EC. It didn't happen. Okay, so, all right. And then Mr. Acheampong. Mr. Acheampong, so, you know, he's also, I don't have any problem, but just remember that, you remember in the 2008 elections, just before the elections, then there was a comment, that's just to paraphrase, he said only those who are afraid of losing the elections would complain about the police and all that. I'm just saying that naturally, while saying we repose all the confidence, it will look one-sided, not to say that, of course, people could have raised a comment or two about the persons. So I remember at that time, NDC didn't take kindly to it at all, and they won the election, remember? Yes, right. And Dr. Abochi, fine lecturer, all that. So that is it. And you know, you see, sometimes we should go perhaps a bit into the commission. People forget that the commission has investigative powers. So in order to do the fact-finding, in the CI 65, they will be using it. There is the power to investigate.
That's Commission of Inquiry Practice and Procedure Rules.
Yes, that's CI 65. Right. There is a power to investigate. So they are going to investigate as much as they can, forensically and everything that it takes. Certainly they will need help, okay, from top-notch investigators and all that, and they have the power to co-op
you just hold it briefly, because I'll return to you because you are the lawyer here, and to deal with very critical aspects of the Commission of Inquiry. The questions about its mandate, the questions about whether or not people can be punished criminally after the commission is done with its work, and a few others. Questions also about how this particular one was set up, whether there was need to go through Parliament or not. Right now, Dr. Enning, the scope, the mandate of the commission is to make a full, faithful, and impartial inquiry into the circumstances of and establish the facts leading to the events and associated violence during the Ayawaso West Wagon by-election on the 31st day of January 2019. 2, to identify any person responsible for or who has been involved in the events, associated violence, and injuries. 3, to inquire into any matter which the Commission considers incidental or reasonably related to the causes of the events and the associated violence and injuries. And 4, to submit within 1 month its report to the President, giving reasons for its findings and recommendations, including appropriate sanctions, if any. What are your expectations?
Let me start with Martin's point about being informed by history. The history of the implementation of recommendations of commissions of inquiries in this country leaves very little hope, particularly when they relate to violence, politically motivated violence, and also when they relate to issues bordering on security and security institutions. I'll cite 2 examples, all within the context of the historical antecedents of the relevance of commissions of inquiry. If we take the police, and I think this is where Acheampong's presence on the commission is very important, and we take the Tibiru Commission, for example, of inquiry, and the recommendations it did with respect to appointments and promotions and exams in the Ghana Police Service. Not a single one of those recommendations were dealt with, leading to where we now have a service in which you do not know whether meritocracy is what drives the processes for appointments and promotions. The second relates to the Archer Commission report, probably the most extensive study and inquiry into how to ensure that the Ghana Police Service performs its original mandate of protecting lives and property under Act 350 of 1970. Archer's report resulted, I think, in a formal white paper from government, of which almost none of the recommendations and government's own white paper on that report were fulfilled. So looking at some of these things, there's quite a long way to go in terms of political will to fulfill the terms of reference. So let me speak specifically to the four very critical issues I think that they need to deal with. I think the 1 month term is horribly short. Because if I take identifying persons, that will take considerable amount of work. They may have investigative powers, but they will need solid forensic support. We've got to get access to laptops. We've got to get access to mobile phones. We've got to draw the networks that support or that have supported the recruitment, the funding, the fractionalization, all sorts of things. It's any matter of interest, that is another extremely wide remit. So I hope that they have a supporting infrastructure that says, talk to Martin, talk to Festus, talk to Acheampong, because they've already done enough work, and there's a body of knowledge that you can draw on. So I think based on what we know of the four individuals, being able to put the facts on the table should not be the problem.
Okay.
The problem is the will to say we will deal with the recommendations.
All right. Okay, so I'll return to you for you to help us deal with the question where you say that and to inquire into any matter which the Commission considers incidental or reasonably related to the causes of the events. Whether, when you say that is wide, it means that the Commission is able to extend its mandate beyond the Ayawaso situation to look at the question of the violence associated with elections and by-elections, because there's been, you know, a long-standing debate and demand for a resolution to that particular development. Now, let's find out what Acheampong thinks, that under Article 278 of the Constitution, under which this commission is formed, it says that the President shall, by constitutional instrument, appoint a commission of inquiry into any matter of public interest. You believe that this matter is so substantial and the way to resolve it is to use a commission of inquiry?
So much so, and not only because of the happenings of the 31st January, but also available data shows that Ghanaians over the years, and in particular to this very issue about this issue of vigilantism. In fact, I am tempted to even change the name. We'll come there. So, for instance, when you pick Afrobarometer survey, as high as 88% of people in Ghana think it's a menace that the country should deal with and deal with urgently. I'll give you the data before I leave here. So it's a matter of national concern And for some of us who have followed elections, and especially by-elections in the country, I was saying at a certain platform that we need to sometimes show a clear video, a full tape, consistently and continuously for everybody in the country to watch, to see. So let me give you my personal experience at Ayawaso West by-election. Because the Electoral Commission had indicated that they were going to demystify the so-called strong room. So they were going to mount a platform to project results directly. And they were going to use the Ayawaso West by-election to experiment their equipment. Then the Kodio board, Professor Greenstreet and Justice Crab, may his soul rest in peace, tasked the Kodio Secretariat to follow that process to see how the equipment will function before we enter into the general election. So we had gone there 3 days ahead, mounted our secretariat, trained and deployed about 30 observers. So in the morning around 8 o'clock, I had a distress call from one of our observers in one of the villages. So I quickly, Mr. Ahin, the coordinator, asked me to follow up. When I went to the police station, they didn't have men, so I had to go along with the driver. We got there, and I had the situation report on my phone, so I was reading. But the driver told me, Anana, the pickup we just met, probably they were those who had gone there to cause problem, but I didn't look at the pickup. Then I went to the polling center, and you could see my observer panting and roaming. He couldn't even formulate his thoughts. Then he said, Nana, he said, you're just going around like that talking. So I calmed him down, said he should speak. He couldn't say anything than to utter just 3 statements. The first thing he says, Nana, they are very fearful in appearance. Nana, they are so dangerous you can't even question them. Nana, they are deadly in their actions. These are the 3 things that he said. So I quickly calmed him down and went to the policeman there, asked what happened, and he explained to me. Apparently, because it's a remote polling center, a motor rider rode him there. And this motor rider had not had any election training. So when he saw the people who had come there, this vigilante group had come there, apparently started doing wrong things, and started filming them. So they got down to seize his mobile phone. That's the motor rider's mobile phone, and started beating him. And when, according to them, they actually beat him. And afterwards, they seized the mobile phone, asked him to delete every picture, video on it. When he finished doing that, they handed the mobile phone over to the policeman at the polling station with the instruction to the policeman, from the vigilante group to the policeman, that he shouldn't hand over the phone to the man until he hears instruction from them. So when even after I've gone there to ask him to give me the phone, he said, no, sir, I can't do that. It tells you the fear even a policeman has in this vigilante group. But the worst happened when I had gone to Mumuni Ekra, one of the polling centers around Samra Boy, to also do my monitoring. As usual, when you went there, you had to take few details, how many people in the register, how many have registered. So I had just kneeled down writing things, somebody tapped me, and I didn't know who was tapping me. I just turned around and saw this man standing there, my brother. I didn't even know how to address him. I didn't know to say sir or boss or what. I was just fumbling with words. Then he never told me anything. Just so I managed to say, oh, is everything okay? He shook his head, walked straight to the pickup. And about 3 seconds, they moved. The question is, why did they do that? Should I also go? Because I had finished what I was doing. It was the same road I was going to use. Should I go? So I stood there for more than 30 minutes. Don't know what to do. Not knowing my driver was also entertaining same fear. So he quickly ordered for coconuts, just to while away time. I'm just saying this to paint a picture as to how they look. But I got to the net. Fortunately, one of the political party executives came around the polling station, and I knew some of them. So I interacted with them, and when they moved, I followed them. Because I knew even if I was attacked, they would come to my rescue. Right. But so we'll go to another center.
As you know, we'll be dealing with this, aspect extensively on this show.
Right.
But what's your level of confidence in the commission to do a good job in this matter?
My brother,
is the commission what we need?
We need a commission. The commission itself, as my earlier contributor have said, is not a problem. My problem here, or my issue, critical issue, will be the aftermath of the commission's report. The aftermath of the commission's report. What we do with the report will be the critical issue.
Okay. All right. So, in due course, I'll be saying 1 or 2 things about the aspects that we have on this table. There are persons whose expertise is sought abroad, not only here in Ghana, and they have worked with the AU, they have worked with various other entities in these subjects. And I'm bringing in now kind of Sabuaje, retired, who is the author of this fat book, Indigenous African Warfare, its concept and art in the Gold Coast, Ashanti, and the Northern Frontiers, territories, up to early 1900s, and also ECOMOG, a sub-regional experience in conflict resolution, management, and peacekeeping in Liberia. This is the second edition of that book, and this other book, two books that you certainly will love to read, especially if you do the work that I do here. Okay. Now, what would be your preferred approach? To use a commission, or to simply allow the criminal justice system to deal with persons identified as having committed crimes?
Thank you. First of all, thanks for the ambush marketing, as you call it in your parlance. And let me associate myself with all the pertinent observations made by colleagues around this table. I cannot fault the authorities for choosing to establish a commission of inquiry. It's a mechanism that is available within law if they so choose. So as they have suggested, there is absolutely nothing wrong with it. The pertinent issue is that we're dealing with an issue bordering on national psychology, national sentiments. And therefore, the key question remains as to whether this approach would sufficiently or adequately assuage public, tensions and public apprehensions and so on and so forth. So to add to the episodes that Martin and Kwesi and Acheampong have already alluded to, I have here the Commission of Inquiry, the WACU Commission, to add to what they have said, right. 2002, which asks the Commission to identify the perpetrators, that is relating to the murder of the Yana that, has become topical now, and make appropriate recommendations. This commission made a tall list of recommendations, and without reading into the details, the commission pronounced itself on the perpetrators, subcategorizing them into murder, conspiracy, attempted murder, causing unlawful damage, assault, arson, illegal possession of firearms, and unlawful military training, giving the linkages between this topic and the other one that we're going to look at, vigilantism. Let me quickly go to page 4 of that report and read what the commission recommended. One of the recommendations: the government should clamp down on and disband all private armies operating outside the auspices of the Ghana Armed Forces, and by extension, Ghana Police Service and other security institutions. So we need to convince ourselves that since 2002, 2003, this particular recommendation has been addressed by our national authorities. And the answer is no. Right. And therefore, there is justifiable grounds for the segment of society that doesn't repose sufficient confidence in the mechanism. Having said that, on the question of the mandate, in addition to the limitation on the time, I think the mandate is too narrow in scope. And sometimes in matters of this nature, borrowing from my experience in the armed forces, on boards of inquiry and related matters, in addition to the broad chapeau as to what it is that the commission must do, you need experts to ask key questions that should guide the commission or the board to arrive at very pertinent findings. And I find these key questions, for instance, completely absent. So it's now left, if you like, to the commission itself to decide on which issues it's going to pronounce itself.
But
there is if I may quickly finish, there is also a tacit assumption that the incident at Ayawaso is a regular issue or was a regular issue. And therefore, there is no attempt in the terms of reference of the commission, the convening authority, to question questions around authorization of the operation, its command and control, its legal basis, and so on and so forth. And these are some of the things that I think the convening authority or order should have explicitly expatiated. It's all part of the process of calming down the public temperature that has shot through the roof.
Okay.
Otherwise, I will not fault the government, but I think we should allow the commission to exhaust that process. And in addition to that, some experts have suggested that nothing stops the police from also carrying out its own investigations. It raises questions about cost effectiveness. Why establish a commission if the normal criminal justice system or institutions can address this issue?
So I'll actually get to Martin to assist us to answer those questions, whether even that is possible and allowed in law, as we have come to know so far. But before I get to Martin, I'd like you to take it up from where he ended, because whilst you see the term D, term C as wide, Canada does not see it that way, because it does look like, even though it says to inquire into any matter which the commission considers incidental or reasonably related to the causes of the events and the associated violence and injuries. It clearly is still limited within Ayawaso and Bawaleshi, so to speak. So is there an opportunity, as you sought to suggest, to go outside of Ayawaso and to look at the broader subject of by-election violence or by-election violence?
No, I think there's an implicit assumption in number 3 that Ayawaso was an isolated incident. That what happened at Ayawaso.
Okay, just hold on briefly for me. I understand I have a little technical problem with your microphone. They'll get it sorted and then we'll return to you. Now, Martin, on the issue that I suggested you would assist us to look at, I'm looking right now at the Constitution Review Commission's reports. You are a student of this report. Sometimes you bring it here. Today you didn't.
It's in my bag.
Okay. Oh, it's in your bag.
No, it's not too much.
Okay, right. Kukubako is not here. You are doing his job. Right. In page 314 going, the commission dealt with the effects of findings of commissions of inquiry under the Constitution. And they pronounced very clearly, emphatically, that because the findings, when they are done, and there is a publication of a white paper, or there is an announcement that there will not be a publication, 6 months after, it becomes the decision of the High Court. And you can only appeal if there's adverse findings against you to the Court of Appeal. Then they refer to the case of Kojompini and Rekubrobe, as in Republic versus these people, where the judge, Court of Appeal judge, sitting as a High Court judge, now in the Supreme Court, Justice Mafusa, was very lucid in pronouncing that you cannot prosecute on the basis of the findings or recommendations of a commission of inquiry. Now, people have suggested that that happens only because that particular instrument gave immunity to the witnesses that appeared before it. The clear point of law now is that because we passed what you referred to earlier, the Commission of Inquiry Practice and Procedure Rules, it has also given witnesses immunity from criminal or civil prosecution. So what do you say?
Okay. So my understanding of it is that in such cases, the immunity would attach to evidence they brought before the commission. So let's segregate them. If the witness brings evidence to you as a commission, then it follows that from the law, you cannot turn around after the commission is done and use that same evidence to prosecute him, because then it's like self-incrimination, which is not allowed even in law, you say. So if it comes to the commission and gives you, let me call it original information that hasn't already been obtained from other sources, then my understanding is that you'll be precluded from using that evidence to prosecute. But it cannot be the case that such a person can never be prosecuted. No, that is how I understand it. So for information he brings to the commission, you cannot use that as evidence. And you know, in the Rekubrobe case, that was the main reason why the ruling went that way, or let me say one of the main reasons, because Justice Mafusan was at pains to show that, look, it was information they brought to you that you've turned around to use to prosecute. And it's like, no, there's a CI doesn't allow it. You remember there was a letter, the prosecution sought to show that they had also commenced independent investigation. But unfortunately, the letter that Iyoko wrote to the police CID said that they have heard there's been disposal of certain assets of the Ghana at 50 Commission, Trasaco Valley and the rest, okay? But when they came into court, the charges related to Kojo Mpianim taking a loan without consent and interest having accrued on same and so many other things. So what I'm saying is that, so in that decision, the judge pointed out that, oh, prosecution, you say you have independent evidence. But it turns out that even the Yoko letter was not what you've used. If you are conducting independent evidence, what I've seen so far is not independent. It's rather the information they brought or the commission's evidence that you're using. So that's one of the pinnacles, one of the main reasons that that case was thrown out. So me reading it this way, that is the context in which I understand the Constitution Review Commission, you see. Because otherwise, then it would be the case that as soon as anybody wants to get immunity, then he will quickly run to the commission and then volunteer some small information. And then as a result of that, pro tanto, it means that he's granted immunity.
I see.
Yes.
But we have just referred to the Commission of Inquiry Practice and Procedure Rules, 2010.
Yes.
This is law we have passed.
Yes, yeah. Which
and
regulation?
In section or regulation 13,
okay,
it says a witness appearing before a commission is entitled to the same privileges to which a witness before the High Court is entitled. Then 14, subject to sub-rule 2, in proceedings before a commission, a person called as a non-target witness or as an expert witness shall be compelled to produce a document or an article and to answer a question with regards to the subject matter of the inquiry, although the document, article, or answer may incriminate that person. So 14.1, that's I read. 14.2 says, where a person gives incriminatory evidence under sub-rule 1, the evidence shall not be used in criminal or civil proceedings against that person.
Exactly. So that's what I'm saying. So the point is that my understanding of this 13 and 14 is not to say that as soon as somebody appears before the commission, then ipso facto, he obtains immunity in respect of any plausible criminal prosecution. No. So you see that 14.2 makes it clear that where a person gives incriminatory evidence under sub-rule 1, the evidence shall not be used in criminal or civil proceedings against that person. Shall not be used. You know, in law, we have this principle of interpretation about clarity of thought. If the lawmaker intended to say that any person who appears before the Commission of Inquiry shall not be prosecuted, they could have said so. And that is what they said in the Ghana at 50 Commission of Inquiry, that CI is at 61. Yes, it was made clear. Is that A2? A2, yeah, of the regulation A2. It was made clear, and other supporting regulations. They made it clear that people who come in as witnesses, they shall not be prosecuted. So it was carte blanche. It was a total immunity. But here, listen to the language. It says, where a person gives incriminatory evidence under sub-rule 1, the evidence shall not be used in criminal or civil proceedings against that person. So is the evidence, as I earlier on stated, what he brings, which incriminates him. You cannot.
Right.
But if
in the Ghana at 50 matter, when the judge made the conclusions, he did not stop there by saying that his hands were tied by the same instrument that the government had issued. You know, giving immunity to the people who appeared before the commission.
Yes.
But he went further to say, and the Commission of Inquiry, Constitution Review Commission, sort of summarized what he said. That the courts in Ghana have decided that, and that is in that case, the Republic versus Charles Rekubrobe, have decided that the constitutional arrangements under Article 280, that is for setting up commissions of inquiry, of the 1992 Constitution, does not allow the Attorney General to initiate criminal prosecution against persons affected adversely by the findings of a commission of inquiry established under Article 278 of the Constitution, and that the findings of commission of inquiry should never develop into criminal trials. The court reasoned that any prosecution mounted on adverse findings of a commission of inquiry will undermine the provisions of Chapter 23 of the 1992 Constitution.
Yes. Yes, so it's still the same, because remember, Justice Mafusa made the point, okay, that because the Kujimpienu had the right to appeal, mounting the prosecution violated that right of appeal. You see, so he came under Article 33 and said that the right of appeal is also a human right. You see, so the point I'm making is that it cannot be that reading all of this in context, that once you come before a commission, you can never be prosecuted. No. The review commission is saying that you don't use those findings. Don't. So if independently you can establish, you investigate, like what
maybe a final clarity on that, where you say independently you can gather evidence.
Yes.
Is it possible to gather evidence which is completely independent of the findings and which may not be deemed to put the person in a position of double jeopardy? As in, you are prosecuting him on the same matter twice, which the law does not allow. So you bring me before a commission. The commission is a high court. The commission's decision is a high court decision. If you want to appeal it, you can only go to Court of Appeal after 6 months. And you say that you have gone to do separate investigation. The separate investigation is about the same matter. So will you not be doing what law does not allow, double jeopardy? You shall not vex a man twice on the same issue.
Yes, Sam, I know. Yes, you want me to answer so that viewers, yes, I know he's posing it. Yes, okay, let's take time and go through this way. Can it be done independently? Yes. You see, and let's not forget, to show how it can be independent, let's not forget that it's not a given that any person who comes before the commission is coming to cooperate. Once again, history should guide us. The Okujeto, the Accra Sports Stadium disaster. Okujeto's report says that the police didn't cooperate. In actual fact, they used the word falsehood. He said that they came and gave false statements. And the commission was at pains to point out that that behavior was so dishonest. You see, so let's not just assume that everybody is coming to make a clean breast of the case. Okay. No. That would be very naive of us. So, if somebody comes, he's very evasive, he doesn't cooperate well, and we can independently establish the commission of a crime. Straight.
Okay. So what sort of punishments can a commission of inquiry give to persons who are found to have done something wrong?
Good.
And so, how is that better than using the criminal process to punish them?
Yes. Okay. So Samson, then the question about, okay, so it's even tied to the double jeopardy. The double jeopardy is a case of so that if you are prosecuting somebody, make sure that you prosecute him in respect of all the possible offenses he could have committed. So let's say if there is stealing and then causing harm, you don't go and prosecute for stealing and then subsequently come back to court that now want to prosecute for causing harm. No, you prosecute all the offenses together. So in a way, it's a kind of estoppel. What you take to court the first time generally would bar you if you could have taken another offense together.
Okay.
So what would happen in this case is that because a commission of inquiry is civil in nature, what they're doing is civil proceedings.
Right.
So the findings are also civil. And there is even an act of parliament in that nature that mentions that commissions of inquiry are civil. I would find one of the 261. Yeah. Okay. Yes. So if we find evidence of criminality, as I said, independently, we can prosecute. Double jeopardy will not arise in this case.
So the commission of inquiry cannot sentence anybody to jail?
Yes. Oh, that is out of the picture. Because you know that the standard when it comes to criminal trials is proof beyond reasonable doubt.
Thank you.
But the commission is not engaged in such an exercise.
So which is your preference?
So
what's your preference?
I said commission, and let me just make a small point about it. As I said, going from RV Jemfi, where the UP man was jailed, and so many other reported cases, it tells you that deterrence is not the only solution. When it comes to punishment, we also have reformative theories. Okay. So just saying an eye for an eye, you see, it's not the best. Okay. So I think that the commission of inquiry, because, and especially looking at the stature, the gravitas of the persons in charge, is going to give us a national opportunity to dialogue again about this thing. Because let's remember, this thing didn't start today. Look, even in Liman's administration, yesterday I was just going through, you know, after the AFRC left and then Liman came in, some of the cadres, there were so many. Liman turned them into what? Vigilante groups and asked them to do community policing. They turned around and started committing crimes. So our history shows that
when we get to vigilante, how sometimes they morph into something
the point is that please let's explore another way of dealing with it, and that using the commission of inquiry route doesn't mean that the criminal door is shut. Criminal prosecution is shut. No.
Okay. All right. So then the before you continue, Dr. Kwesi, with your point, then the questioning again is, if we still look at the potential of prosecuting, what's the point in doing a process? He just asked that question. Festus Abaji just asked that question. What is the point in doing this and then doing the other? Waste of resources?
Well, after listening to the two lawyers talk, I just felt that this is actually going to worsen the problem than resolve it.
How?
I cannot basically see people going scot-free. You can't vex a man twice. This nation has been vexed by these attacks since 1951. Commissions of inquiry, whatever you want to call it. And I'm happy Martin has brought in the Okujeto report of security institutions that have been criminalized over time. And for example, the Tubiru inquiry says within some security institutions, they've become so criminalized in falsifying official documents that you cannot determine the difference between the original document and the false document. Nothing was done. So we have a long history of waxing lyrical whilst the country bends. And as I listen to the two of you, and I watched the video that you put up there, I could see people smiling and saying, listen to them. We will teach this country a lesson next time there's a by-election. Because we are tinkerers, we like to tinker with the problem whilst this country burns. Probably we ought to have inverted the process and discussed the problem prior to the attempted solution. Because that would have probably made it much easier. Because when we come to the vigilantism bit, or the term here, creeping, this is no more creeping, Chief. This has engulfed, taken over the country, and it's now the most crucial existential threat to Ghana. Okay. So that would have dealt with this, but be that as it may.
So back to the point you were about developing about the term 3 being wide, and what can it take on in addition, so that this does not become investigation only for Ayawaso, but for
a much wider. But you see, it also says it gives the members the privilege of choosing what they think they may want to bring on board. Okay, and I think this is much bigger and too dangerous to give 3 people that privilege.
But whatever they pick and choose must be related to the Ayawaso by-election violence.
Or what brought us to Ayawaso. And the underpinning dynamics that led to Ayawaso. Ayawaso is not an isolated event. Ayawaso is the culmination of almost 70 years of glorifying violence in this country and using violence as a currency.
Interesting.
And also creating parallel non-statutory security institutions that have more power than the statutory security institutions. You know, so when we get there, it's all about issues of loyalty, and Festus is here. How do statutory security officials who have been trained or recruited, trained, and have the institutional ethos of discipline, suddenly feeling that people who have been trained for 3 weeks are better armed, better paid, okay, and can behave in ways that they want? We've just done a major study assessing the motivations and attitudes of the next generation of African security sector professionals. And for the younger officers, they don't owe the same allegiance that Festus owed. So what Ayawaso is teaching us and what this commission must try to unravel is that how will these people in uniform feel when their institutional ethos has been thrown out of the window by the political class, who they should always salute and say, yes, Amasatu. This commission probably is our possible last chance prior to getting into chaos. Because the guns are there, over 2 million unregistered. We've become a major international transit point for guns, some coming in as far away from DR Congo to be traded. Okay? We've got a bunch of lumping proletariat whose only claim to fame is criminality and violence. They've got tapes and recordings of how people have recruited them and given promises that they can't keep. Ayawaso demonstrated to us, and this is what the commission, what number 3 is key. And I think my elder brother Festus related to. Who recruited you? When? Where were you trained? Who trained you? How much money do you get? And this is where Parliament has failed us. Because money has gone into these guys, their recruitment and their training. So that some of the concern about steps that could have been taken prior to such a commission, that a Parliamentary Committee on Defense and Interior has the authority to have called ministers to answer questions. Public accounts and the finance committees, they approve monies to be used. You know, so we are just dancing around the pot, okay, and using Oxbridge English and interpretations. And look, let's cut to the chase. Let's cut to the chase. Because look, let there be a by-election in another 2 weeks. We will see violence 3 times. I'm telling you, because I can read messages now from statutory officers in the security forces, okay, who feel disempowered. If they put the tapes back on, that police officers were frightened even to separate these goons. They stood aside because they will be sacked if they had prevented what was happening.
That's how serious it is.
The impression that I haven't even started yet. The impression, and when he comes in, people will not be able to have lunch. The impression that we have given.
So let's quickly conclude on this commission and come to this point. It is not my intention not to want you not to have your lunch. But earlier you were making some prescriptions. Maybe, just maybe, the commission may have the benefit of the prescriptions that you are seeking to make. You spoke about the fact that they will need experts to do forensic analysis. But it is becoming obvious that they may even need more than that. They will need people like yourself, like Festus here. I mean, what do you have to tell the commission before they start their work?
Get all the tips, the history of political violence, a history of non-statutory security forces, arms flows, follow the money, okay? Because that money will lead us. I think on this thing here, if you Google political vigilantism in Ghana, I think there are more than 350 articles that come up of senior political officials saying, we won't disband, we will form this. If we be able to trace the money, okay, and we can get JIBA, that is the Intergovernmental Action Task Force from Dakar, this is an ECOWAS body, whose sole expertise is in tracking money. And I can assure you, we will track the money, and the results will not be good.
Interesting.
But we will get there, and we will provide some
so obviously,
so I hope they will invite us to appear.
Right. Obviously, like the commission of the Constitution Review Commission said, the times that are normally given to these commissions are so short. They are not helpful. They acknowledge that. And Colonel just acknowledged that as well. I've been reading some work, and I've seen CDD and your experts writing about these violence and how they keep recurring and so on. We'll refer to some of them. But if you had the opportunity of sharing some advice publicly to the commission, what will it be? They are listening.
If I had the opportunity to advise the commission what they should do, Quakyi and Colonel have intimated some of these things. The Ayawaso by-election is the culmination of hatred, animosity, mutual distrust, and undermining of formal security that culminated into the Ayawaso by-election. So if I had the opportunity to advise them, the extra window that has been given by the terms of reference must be looked into. What is the antecedent? What are the sources of their power? Who formed them? Who capacitated them? So some of these things should be explored to us to expand the network, because as Martin said, he likes it because the report from the committee is going to serve multi-purpose, not only for criminating people through the criminal justice system, but also initiating a dialogue. Some of these things will give us the window, the avenues, who we should approach. So I would advise them to expand the third window that has been given to look into any other issue related to the
critical point, though, is where is this optimism coming from when you have acknowledged, and here we are dealing with people who know what they are talking about, and you are referring to Commission of Inquiry reports that are still gathering dust. Nothing has been done. So where's the optimism coming from that when they use this vehicle, it will result in anything? And you know the nature of the white papers that are issued, they cherry pick.
Oh yeah, sure.
Yes, you have recommended we should do A. We don't believe in A. Forget it. We'll do B.
Because it said probably this is our last chance. This committee is our last chance to move ahead.
Okay.
And let me say, it should be our last chance because, you know, we are in 2 critical years, 2019, 2020, critical years for us. In 2019, we are looking to touching a referendum to elect MMDCs to local government elections. And in 2020, we are doing the usual parliamentary and presidential elections. So these are the 2 critical years before us. This committee must serve as the good and expand them so that, I mean, as Kwesi said, it should be our last committee we are going to think of. So that's why I said the aftermath of the committee's report, it was critical.
Okay. Thank you very much. Now, I'd like to have Colonel help us to conclude on this subject by looking at some suggestions or questions that have been raised by former Chief of Staff, Nana Atto-Dadzie, also former senior UN consultant on political transition. He wrote and said that he wished to place on record the following views on the ongoing public discourse. Number 1, the calls for a judicial commission of inquiry, though well-intentioned, may only serve a diversionary course. 2, the Minister of State for National Security, Honorable Bryan Acheampong, on the basis of his admitted violation of the Security Act and his direction of the assault during the by-election under that guise, must immediately resign his office. He must cause the president no further embarrassment by waiting for the demand of his resignation to do so. 3, the Inspector General of Police, as a matter of personal honor and principle, must resign his office for entertaining the violation and abuse of his command by the intrusion of an unconstitutional paramilitary force, the transportation of the offending persons in official vehicles of the Ghana Police Service, and their display of branded gear of the same reaffirms this demand. The same must be said of the sad spectacle of the helplessness and non-intervention of senior police officers at the scene. Dr. Eni referred to this a while ago. 4, the unconstitutionality of the paramilitary force in question is beyond debate and does not require any pronouncement of the Supreme Court of Ghana to affirm the same. It must be disbanded with immediate effect. Last, I'll read just the 5th point. Holders of public office must remind themselves that immunity in Ghana today will not serve as protection from future prosecution at the International Criminal Court on the basis of human rights abuses and crimes against humanity.
Thank you. I think on the question of the...
Some have actually added Kan-Daapah, that all 3, he, Bryan, and IGP must resign honorably.
First of all, on the first point of, may I call him Nana, seeing this as a diversionary tactic, I think we've spoken a lot about that. So it behoves the, I wouldn't want to use the word government, the national authorities to dispense with that view.
Okay.
You know, and disabuse the minds of Ghanaians that this commission is not going to be a diversionary tactic. Taking points 2 and 3, the question of or around Honorable Bryan Acheampong, and you have added the Minister for National Security and the IGP.
I spoke to Bryan Acheampong on this show last week.
These 2 paragraphs.
And he admitted, you know, being responsible for the men who were on the ground.
In these 2 paragraphs, Nana and those who may associate themselves with this stance are referring to the issue that I raised, command and control of the security sector. Now, I would wish to go into history and cite Clausewitz, you know, a Prussian general, who said that the whole purpose of, first of all, recruiting, of equipping, of clothing, of feeding and training, and by extension the armed forces or soldiers, is so that, and then he has the objective. So there is a purpose in the recruitment, in the clothing, in the equipment, in the feeding, and the training of the elements that we saw at Ayawaso. There is, at the bottom of it, a command and control issue of a political and operational nature. And I think that underscores these two paragraphs. Who recruited these elements? Politically, whose decision was it? To suggest that they have been embedded either in the Ghana Armed Forces, but specifically with regards to Ayawaso, in the police service, to the extent that the two have become, symbiotically linked. Can use police vehicles and, facilities, and then on top of that, you layer the national security elements that we saw. There's a question of parallelism that I think Nana is also suggesting, and that's very worrisome. Kwesi alluded to that. In our own history, without going too back into history, when we had the President's Own Guard Regiment, at the time when Nkrumah could not trust the armed forces, he created the President's Own Guard Regiment. And may I say, your senior citizen, our senior citizen, Zalerigu, was made the commander. It created tensions within the armed forces. Because the POGR was very well equipped, very well looked after. And that was one of the reasons why Kutuka and the other generals got rid of Kwame Nkrumah. During the revolution, we had the episode of the Junior Leaders Company called the Boys Company. Very well trained. Many of them marched themselves from their units and got to Gonda, what I call the Gonda syndrome. So Gonda created tensions within the regular armed forces. Because those boys, and only God knows who was commanding and controlling them, undermined national security. Maybe it served some other purposes. Then we have the 64 Infantry Regiment. And that was the last time that we had to grapple with a regiment that was created, very well resourced. Not many of us would know. But in this Ekomok book, at a time when, may he rest in peace, General Yuku and our former CDS, General Dankwa, needed military capabilities, i.e. mortar bombs. The mortar bombs were not available in the regular armed forces. They were only available in 64 Regiment. So a detachment of 64 was sent to Liberia to provide that support. Is that where we've got into? And it's very obvious that those forces that we saw at Ayawaso, very well equipped, very well marked with all those gas masks and so on, very confident, very well built. Of course, you cannot be very well built if you are not eating well. And eating well means that your pockets are good. So there are very many dangers in the Ayawaso incident, and maybe that's why somebody said it's God sent, that we need to learn the right lessons. But let me not bore you with the idea that in our culture, nobody resigns. If some of our seniors in government had been Americans, by this time, many of them would have resigned, or some of them would have resigned.
That's
as
correct.
the Secretary for Defense resigned when his own Commander-in-Chief decided arbitrarily, without consultation, to withdraw U.S. forces or U.S. presence from Syria. So resignations, yes, to the extent that confidence in the police service has been undermined. Even if the IGP stays, we need this commission to contribute to the solutions by creating conditions that will serve as disincentives for anybody to want to allow themselves to be used or misused by persons in authority.
Okay.
These are the few comments that I think I can add to the debate at this stage.
Thank you very much. And for those who had suggested earlier that there was an announcement and there was no CI. I'm sure now you are convinced that there's a CI. It's a CI 111, and it was gazetted on the February the 6th, 2019, CI 111. And after we heard that there was a CI, there were those who were raising questions that it ought to have gone to Parliament. I'm sure we have had sufficient education on that. And Justice Ramsai, who teaches at the Gimpa Law Faculty, has a very brilliant explanation to it. And he says, I'll just do that quickly and then we take a break. When we return, we'll be speaking to the Secretary to the Commission. He says, Justice Ramsai says that there are two types of constitutional instruments, CIs. There is type 1, that are those that are legislative in nature, and then there's those that are legislative in nature, and there are those that also, those that are legislative in nature seek to make law. Then type 2 are those that are executive in nature. So the one which is executive in nature seeks to execute an already existing law. It is only a type 1 CI which requires laying before Parliament. That is the one used to make law. That requires laying before Parliament before it becomes effective. This type does not. And in fact, there is evidence to show that it can actually be made also by an EI, executive instrument. We'll take a break, return, speak to Dr. Ernest Kofi Abochi, and then we'll deal with the bigger question of political hooliganism, or is it vigilantism, and how to end it. We'll be right back.